Right. Good morning and welcome to the District of Columbia Court of Appeals. I'm joined this morning by Associate Judge Roy McLeese and Senior Judge Eric Washington, and I'm Chief Judge Blackburn Rigsby. And we have one matter set for a special sitting this morning. Are parties ready to proceed? All right.
Yes.
Okay, and Ms.
Jai.
Najai is joining us remotely. Before we begin, can you inform the court as to how you'd like to divide the time for amicus and appellate?
So we'll be dividing our time 11 minutes.
I'm sorry, if you could step to the microphone just because it's being recorded.
We'll be dividing our time 11 minutes for the opening argument, which will be done by me, Ms. Taylor Stabline, and then 4 minutes for rebuttal by my co-counsel, Mr. Garfield McIntyre.
Okay, I guess the division of time for the appellees, is there going to be any division of time there?
There's not going to be any division of time.
Okay, and we tend to be a little err on the side of being a little generous with the time if you require additional time that's relevant to your arguments. Ms. Najai, were you planning to argue, or is the amicus presenting the full argument on your behalf?
Well, I'm prepared to argue. I thought that's what I was going to do if I can. And if I can get the 15 minutes with 3 minutes for rebuttal.
Okay, and so who's going to go first again? Are you going to go first, Ms. Najai, or?
Sure.
Is that consistent with what we just said?
Yeah.
Okay, all righty. All right, thank you, Ms. Najai.
My name is JACQUELYN BRENEA Jai. I am the appellate, and I already asked for the 3 minutes, if I can, rebuttal time. May it please the court that I begin.
All right, please begin.
Okay. The DC long arm statute for a government exception should be limited to appellees' contact with the state, especially because the long arm exception does not protect them from the tortious business transactions done in DC that cause adverse harm in the state to JAI, the agency, which is the U.S. Department of Education, and the state, and for which the claims in the complaint arose. The facts, evidence, and law provide that both general and specific personal jurisdiction in DC exist on multiple levels in this case, and why the scope of the certified questions should be more comprehensively broader to include all relevant and statutory factors as follows. The acts and omissions or contract with the forum state are continuous and systematic business transactions. Number 2, the acts and omissions or contract with the state constitute enduring relationships from 1986 to 2025 to this day. The acts and omissions of the appellees, that is, with the forum state go beyond any First Amendment defenses, despite the claim that they are incidental and insignificant contacts, because the appellees purposefully agreed to waive their rights to another state's general or specific personal jurisdiction in exchange for transacting and soliciting business and rendering service in DC, and for the protections and benefits for that state that they persistently enjoy. Number 4, also, the answer to question number 1 should be yes, because due process clause in terms of fairness and substantial justice to the defendants have already been met. All of the elements of the DC long arm statute, sections 13,422 and 13,423A1 through 6 have been approved by the Congress. And yes, because the forum state has a right to adjudicate its own federal laws, contracts, and statutes that the appellees have violated. Based upon the above more comprehensive circumstances of this instant case, this honorable court rightfully took it upon itself to establish those certified questions, and notwithstanding the lower court's decision to dismiss. However, even though the appellate agrees that the errors or doubts in the lower court's decision should rightfully ignite the first certified question, she also takes the position that the narrow interpretation limits jurisdiction to this case, where the jurisdiction would be granted, while substantial justice calls for a more broader interpretation that would be the content for which the court may liberally construe in light more favorably to the plaintiff, because the second question, in terms of a 12B6 dismissal, requires or relies upon that very thing, namely to accept all facts as true, and not just section A1, but A1 through 6 that exist in this case. Also, despite the appellee's New York University and LIU's erroneous claim that since the appellate requests for a broader scope of the long arm statute prongs from just section A1 to extend to 2 through 6 is somehow conceding to their argument that the long arm statute government contact exception is allegedly not limited to the First Amendment contacts with the forum state, but to the contrary, her position is not tantamount to broadening the limitations beyond the First Amendment, nor the due process clause that are required by the statute. But she is specifically pointing out how their acts and omissions are broadly equivalent to proving that they are not based upon accidental and non-significant contacts, because they go beyond or outside of the First Amendment to more of a purposeful and systematic relationship with the foreign state, and entails the granting of general and specific personal jurisdiction, and answering yes to question number 1 more fully. To those ends, the basis for the appellate's argument leads her to cite broader legal basis for which this forum state has granted a long arm statute in very similar cases with far less minimum contact, as it reasoned in the District of Columbia versus Facebook Inc. case, and the Mallory versus Norfolk Southern, I guess R is railroad company, I guess it's R. Company cases, where the state found that 1, there was specific personal jurisdiction, the due process clause was satisfied, all of the DC long arm statute prongs, including A1 through 5 or even 6, were included, that as a condition for transacting business in the forum state, in the Mallory case, the state can require the defendants to waive their right to any other general personal jurisdiction in exchange for the benefits and the protection of working in that state, as the defendants do in DC. DC has a statute code or rule, as does PA in the Mallory case. To those ends, in the case, the District of Columbia versus Facebook Inc. case number 2018 CA 871-15B, referencing an order dated 3/22/2029, the district court denied the defendants Facebook's motion for dismissal pursuant to an alleged non-general or specific personal jurisdiction, but granted the specific personal jurisdiction as follows: that even though there was no general physical jurisdiction, because Facebook was like 99 or so on 9% online, however, there was specific personal jurisdiction because Facebook's online contact constituted a storefront for doing business in DC. The due process.
I had a question for you.
Sure.
You have said, you've referred to both general jurisdiction and specific jurisdiction, and you mentioned the provision, the statute in the DC code that relates to general jurisdiction, DC code 13422. And so I gather that you're arguing today that you think that the requirements of that statute were met. And I don't know if you have the language of that statute in front of you or if you're familiar with it, but it says, its title is personal jurisdiction based on enduring relationship, and it has as the circumstances that cause the statute to apply that the person is domiciled in, which is again a legal term, organized under the laws of the District of Columbia or maintaining a principal place of business in the District of Columbia. Do you think that the university defendants here would meet any one of those requirements of that law?
Yes, Your Honor, because the university, the New York University, LIU, ICR, which is the immediate credit recovery, and FMS, all have they have businesses in DC. They have offices in DC that they never said anything about. New York University even rents out their property to the government, to students, or whatever. They have what you call registered agents in DC, even though they filed the motion claiming that there's no personal jurisdiction. So if they are domiciled and they even have a contract with the Department of Education that specifies that most of the work that they do in terms of the federal student loan program happens in DC or by or and through DC. So with that, I think that should constitute general personal jurisdiction, as well as specific. I was going to get into it more deeply with the specific personal jurisdiction. I hope I answered your question.
Wasn't it the specific jurisdiction question that was at issue initially before the matter was certified to this court? The question of whether the university defendants were transacting business here in the District of Columbia. I think all of your responses to Judge McLeese about that them having registered agents and business offices here seem to relate maybe in some ways more clearly to the notion of specific jurisdiction under the transacting business provision of our statute.
That's right, Your Honor. And also their contract spells out specifically that they have to abide by the DC laws through the Department of Education in order to they get profits. We're talking about millions of dollars in profits from DC that they enjoy, and they're protected in other ways. But it spells out that if they violate the laws that are specifically termed and conditioned in their contract, that they are jointly and severally liable. And in DC. So
Isn't that, is it's, so your understanding is if DC law applies, then the case has to be heard in DC, as though New York courts could not apply DC law?
well, I'm not necessarily, Your Honor, I'm saying that even if New York can apply DC, can apply the same long arm statute or whatever it is, the actions that and the injury and the transactions in the business all go through the DC FAFSA databases, as in Facebook, when they were determined, it was determined that there was specific jurisdiction in Facebook when they were 99% online. And they also, but they're nationally have customers, even in DC, for which they use their confidential information and cause injury in DC. So if the injury is in DC and they're in DC and their contract is in DC, I don't understand why there wouldn't be either general personal jurisdiction or specific personal jurisdiction. I hope I answered your question.
Thank you, Mr. Lai. I know you've reserved your 3 minutes for rebuttal, and so we'll hear from you again during your rebuttal time.
Thank you.
Thank you. Ms. McIntyre? I'm sorry. Ms. Stablen, I'm sorry.
Thank you, Your Honors, and may it please the court. My name is Taylor Stabline, and I'm here alongside my co-counsel, Mr. Garfield McIntyre Jr. We are appointed by this court as amicus in support of Ms. JACQUELYN Najai, and we are asked to address 2 related questions. First, whether the government contacts exception to personal jurisdiction is limited to First Amendment activities, and second, whether the university's contacts with DC in this case fell within that scope. This court should hold that the exception is limited to First Amendment activities, but that it doesn't apply here. Turning first to the question of scope, DC courts have reiterated on several occasions that the First Amendment remains the only principled basis for the government contacts exception. And this court's en banc holding in environmental research versus Lockwood does not change that. The universities are asking this court to extend the exception to unduly broad categories of contacts, carving all contacts with federal governmental agencies out of the jurisdictional inquiry. But that is unsupported by the 2 specific policy reasons why the exception was created almost a century ago.
Can I ask you a framework question first? Ms. Najai, I apologize if I'm mispronouncing that, indicated that from her perspective, the possible jurisdictional predicates that were at play here include the general jurisdictional statute 13.422 and then subsections 1 through 6 of the long arm statute, which is a specific jurisdiction statute. Is that also your understanding, or is your discussion of how the government contacts exception functions applicable to all of those sections, or have you focused on any particular one of them in your analysis and thinking?
As amicus, we express no opinion on the general versus specific jurisdiction issue, but we are focused specifically on the transacting business portion of the statute, which is in section 423A1. So turning to the history of the government contacts exception for.
I ask you to start when you start with your history, because you mentioned ERI, but the government, you also mentioned that the government contact exception goes back to century. So if you start with just sort of the first, the first case, which doesn't seem to implicate any First Amendment, or doesn't, at least it's not discussed in terms of First Amendment or due process.
So the first case we look at is Neely, which was decided in 1932, which was out-of-state entities reaching into the district for news information in a manner that mirrors the First Amendment right to freedom of the press and free speech. And 13 years later in Mueller-Brass, the court looked to the right to petition the government for information. And ultimately, in its later decisions, this court has discussed the First Amendment gloss that was added to the government contacts exception as a result of those two cases.
Can I ask you about the interaction between ERI or Lockwood, whichever we're calling it, and Rose? Because I think a line of thinking in some of the cases that have been struggling with the interaction between those two decisions and your opponent's arguments sort of have the line of the thinking that Rose just misinterpreted Lockwood. And to the extent Rose purports to say that the only part of the government contacts exception that made it into the new long arm statute is the part that is rooted in First Amendment concerns, that's just not a correct interpretation of Lockwood. And so I'm interested in that's a point of particular interest to me. And one question that tends to maybe, or at least arguably support that line of thinking is that in Lockwood, the discussion of the First Amendment is in a footnote that says we believe, but we don't have to decide that there's a First Amendment problem. That's a paraphrase of the rest of it. But the first part is, I think, pretty much we believe, but we don't have to hold. And so it is difficult to see as an original matter how a later decision could say ERI, the understanding of ERI is that the First Amendment is the only thing that's left, when ERA expressly said we're not holding anything about the First Amendment. So can you help walk me through that challenge?
Yes, to explain the relationship between Rose and Lockwood that was 2 years earlier is that Rose merely clarified an issue that the Lockwood court did not need to address. Turning to the actual facts of Lockwood, the ultimate holding was based on due process grounds. There were two categories of contacts. The first was that the plaintiff was doing the reaching into the district on the defendant's behalf, and that didn't reach the scope of the long arm statute. And the second category of contacts, the court looked at the defendant having a couple meetings with the EPA to discuss various matters, and ultimately held that that limited presence in DC was not enough to bring that contact within the scope of the long arm statute. Your Honors, this is
do you view that as a due process holding or an interpretation holding about the scope of the long arm statute?
We view that as a due process holding, and that is because in Lockwood, the court mentioned that the extent of the modern long arm statute that was passed in 1970 is to give jurisdiction to DC's courts to the full extent as allowed under the due process clause. So to the extent there is an inquiry into whether the long arm statute is applicable or whether due process has been met, this court has articulated that those two steps in the inquiry are almost merged together into one step.
But if that's a due process holding, I guess Lockwood becomes very confusing if you're reading it as saying, with respect to that second category of contact, the meetings, the due process clause would preclude consideration of those contacts in support of meeting the statutory requirement. it's very puzzling why Lockwood would say there's also this government contacts exception that's robust and we're kind of recognizing it as existing under our statute. What they should have said, if on your way of looking at what they held, would have been more like what Rose later said, which is, to the extent there's this government contact exception that's been floating around, it really isn't needed for due process purposes because the due process clause itself will perform that function. And then, of course, Rose says the way we think it makes sense is really as a First Amendment decision. And so it's just the idea that ERI is a due process holding is a little hard to square with the way it is worded and explained. Is there a place where you think the language of ERI is most congenial to the idea that it was a due process holding, a constitutional holding, rather than a statutory interpretation holding?
Yes, there is a place. It's in the final paragraph of the main portion of the opinion that states that the limited presence in DC fell beyond the permissible reach of the long arm statute. And that was looking specifically to that second category of contacts between the defendant and DC. So the issue there was that defendant didn't meet step one of the inquiry, which is bringing their contacts within the scope of the long arm statute. And then the government contacts exception functions to carve back at that level of jurisdiction ever so slightly. And that was the issue that needed to be addressed in Rose. Because in Rose 2 years later, minimum contacts were met. There was enough there to bring the defendant's activity within the long arm statute scope. But the issue was whether the case could ultimately still be dismissed on a 12B2 motion to dismiss for lack of personal jurisdiction, instead under the government contacts exception. And because that party failed to raise First Amendment concerns and only raised due process concerns, that case was remanded with invitation for that party to brief on whether their contacts fell within the First Amendment.
So you don't see Rose and ERI as inconsistent. You see Rose as a continuum or building on or clarification of ERI. ERI also identified some prudential concerns that Rose doesn't seem to address at all. And I'm wondering how important, if at all, are those ongoing concerns? In some respects, they seem a little outdated in today's economy and the increasing presence of entities interacting with the government and federal agencies in DC, both for purely business reasons and also for First Amendment reasons.
Yes, to touch on the prudential concerns, those concerns are very similar to the concerns that have been raised by the universities in this case, namely to avoid the creation of a national judicial forum for the adjudication of loan disputes. But 3 years ago in Okmeshkin versus Browder, this court addressed that issue and provided 2 additional backstops to move a case out of DC if those concerns do arise. They're just not the government contacts exception. The traditional fundamental fairness due process inquiry can still apply if a case doesn't arise out of a defendant's contacts with the district, and forum nonconvenience is a viable doctrine that the Supreme Court recognized back in 1947 in Gulf Oil. And because of this, the First Amendment is the proper scope for the government contacts exception. And turning to the university's actual contacts with DC in this case, these were revenue generating commercial contacts.
Can we, before we move to that, if I may, to the extent we're now kind of trying to figure out if that's kind of a transition to the second question in a way, like what are they alleged to have done that relates to the district, and to what extent are those First Amendment activities, if that's the framework we're going to be comparing them against? It would help me if you could tell me what you think First Amendment activity, that phrase First Amendment activity, means. Do you think it means, I'll give you 2 options and you can pick others as well, so I don't mean to limit you, but do you think it means like expressive conduct that within the, speech and expressive conduct that is covered by the First Amendment? Do you think it means, or obviously petitioning activity for other parts of the First Amendment? Or do you think it means something broader than that, things that have a speech flavor, or something more? And if you want to, also you can say whether you think it is limited to exactly that, or whether things that are incidental there too could also be covered.
It's not necessary to create an entirely new definition for what constitutes a First Amendment activity, but rather this court can turn to existing federal laws articulated by, for example, the Supreme Court about what constitutes First Amendment activity. But looking specifically to some prior cases.
Was that, I mean, First Amendment activity is not, at least to my knowledge, it isn't a well-defined term in Supreme Court law that says here is the universe of quote First Amendment activity. That's kind of, it's a phrase we used, I think, at least in Lex Tech, so in one of the decisions. So I don't mean to criticize the DC Circuit for picking it as a phrase that it passed along back to us. But do you think that's a clear concept in at least Supreme Court law, so we can go figure out what First Amendment activity means by looking at some Supreme Court cases? Or
Chief Judge Blackburn-Ridsby, I see my time has run out. May I take a moment to answer the question?
Yes.
Thank you. To provide a little bit more clarity as to what this exactly looks like in terms of the government contacts exception, there are a few examples from prior jurisprudence that exemplify this, turning first to Neely in 1932, where an out-of-state entity was going into the district seeking news information for out-of-state distribution. This would be an example of something that falls within the First Amendment. 13 years later in 1945 in Mueller-Brass, the entity was merely having meetings to petition for information from the government without actually entering into a contract. That would be an example of a time where the First Amendment would apply. And turning to Nartex, the court assumed that this fell within lobbying activities, fell within petitioning the government. That would be another example. But here, what we have is the creation of a contract between NYU and LIU and the Department of Education, which ultimately led to the garnishment of Ms. Najai's income tax checks and Social Security checks because of the contract that was formed between those entities.
So where, I guess, in today's world, Ms. Najai mentioned the Facebook case, and where do we draw the line between commercial? Are you saying commercial interaction with government entities is not First Amendment activity?
Yes, Your Honor. The line we're drawing is the line between a mere contact and a contract with that governmental entity, where that constitutes transacting business. And
Right,
that's
but the mere contact and the transaction of business and First Amendment activities, I guess, where do those fall along the lines? I mean, you have so many people, for example, government contractors. Is a prospective government contractor who comes into DC to meet with federal agencies about the process of obtaining contracts with the federal government. Is that First Amendment activity, or is that commercial activity versus a government contractor who has a government contract with a particular government entity? The work is being done in a different state like Tennessee, and they come back and forth regularly to talk about the contract. I mean, which of those is, if either, are First Amendment activities and which are transacting business?
an out-of-state entity merely coming to DC to speak about contractual requirements would be covered by the First Amendment, and the exception could likely apply. And that is exemplified by Mueller-Brass, because that is what the party was doing there, coming in to meet with the Department of Defense for information about production of materials during wartime. And turning to another case, Vandel versus Arabian American Oil Company from 1965 out of the DC Circuit, this is the line that court drew. In that case, the defendant's activities were no different than Neely and Mueller-Brass, where they were coming in and merely keeping relationships with the government and getting information about diplomatic governmental missions. But the court reasoned that in a different case, had the defendant brought a representative into the district for the purpose of entering into commercial contracts with those agencies, then it's possible that the exception would not apply. Now, that wasn't the case in Vandel, but that is the case here.
can I ask you, I have the impression that there is a factual dispute about whether there actually is a contractual relationship between the university defendants and the federal government, Department of Education, or some component thereof. Do you agree that's factually disputed? And if so, Do you think for current purposes, we should assume the truth of the allegation in fact is contractual in character? Or how do you think, first, is it factually disputed? And second, then what do you think, if it is factually disputed, we should be doing about that factual dispute?
We don't believe there's a dispute here, and given that the procedural posture is on a motion to dismiss, the allegations in the complaint should be construed as true. And to the extent that the universities take issue with the actual allegations by Ms. Najai, this should not be remedied by dismissing this case in its entirety. It should be remedied by giving her an opportunity to engage in something like jurisdictional discovery, to discover more about the actual process of the universities reaching into DC to contract with the Department of Education on this issue. But here, looking to the actual allegations in the complaint, what Ms. Najai pled was that the universities went into DC and fraudulently signed her name on these loan applications, which were then improperly certified by the secretary and the Department of Education in DC, which ultimately led to the engagement of these third-party collection agencies in the garnishment of her income through the Treasury Offset Program, which is the key harm that she's alleging here. And because of this, the universities are asking this court to shield them from Ms. Najai's claims by invoking this narrow jurisdictional doctrine. But the government contacts exception is exactly what its name implies. It's an exception. It's a limited carve out to the jurisdiction that DC courts can exercise. But what it isn't is a broad sweeping blanket of immunity for defendants like NYU and LIU that reached into the district not to exercise First Amendment rights, but for commercial gain.
Can I back again to the question of what First Amendment activity means? Do you understand the government contacts exception as you believe it, survives post Rose, to require that the party invoking it show that reliance on the contacted issue as part of a basis for asserting jurisdiction under the long arm statute would offend the First Amendment, that it's unconstitutional under the First Amendment to consider it? Or do you think instead it's a more of a kind of a doctrinal avoidance or statutory interpretation question about we want to be careful and therefore we don't want, if activity seems First Amendment-ish in some way, it shouldn't be counted because of First Amendment concerns, even if it wouldn't violate the Constitution, the First Amendment to do so? Which of those do you think it is?
Be the first option. The party seeking to invoke the government contacts exception should show why their contacts with DC fell within the First Amendment scope. And turning to the actual statutory interpretation.
But again, that's my question may have been blurry, so let me try to clarify it. Let's say that I am a defendant who is being sued in DC, and there's an issue about whether personal jurisdiction is properly found. And one of the contacts is that I came into DC and I made a speech. Clearly, First Amendment, that's protected by the First Amendment, giving a speech in general. In order to have that not counted as part of the contacts against me under your understanding of the government contacts exception, would I have to show as a matter of law that the First Amendment prohibits counting that? That's just that's an unlawful principle of the First Amendment, that anybody could use that as a basis to assert jurisdiction on me? Or is it enough that I say that activity was protected by the First Amendment in general, not that the First Amendment itself prohibits consideration of it for long arm purposes? Which of those two things do you think it is?
It wouldn't be a showing as in a matter of proof by that particular party that wants to invoke the exception, because most often this is arising on a 12B2 motion to dismiss for lack of personal jurisdiction. So the court would be looking to the allegations in the complaint.
But I'm trying to ask a legal question. So again, so my question is, let's assume that everybody agrees that in the hypothetical I was giving, that conduct is First Amendment activity in the sense of the First Amendment protects that to the, in the sense that if someone tried to impose criminal consequences on me, that'd be unlawful. So it's covered by the First Amendment. It's expressive speech. It's the core of the First Amendment's protection, that component of the First Amendment's protection. Is that enough? Or do you think that the government contacts exception is triggered only if not only is the speech, and this is a legal question, not only is the speech issue, the alleged conduct here, speech, covered by the First Amendment, but that the First Amendment prohibits, this is a First Amendment doctrine that says one thing you can't do to people who are speaking is rely on it as a contact in order to support a conclusion of personal jurisdiction? Do they have to show that the First Amendment prohibits such consideration, or just that this is First Amendment type speech?
The party would not need to show that the First Amendment prohibits such consideration, just that the actual contact fell within the definition of a protected First Amendment activity. And this is the analysis that courts have taken when looking to the government contacts exception, looking to the contacts by that particular party and comparing them to those prior cases that I mentioned, like Neely, Mueller-Brass, Nartex, and whether they look like those cases where the court has validated applying the government contacts exception and ultimately concluding that it cannot assert personal jurisdiction over that party.
The reason I asked the question, or part of the reason I asked the question, is because at the end of Rose, what the court says about the remand to address First Amendment issues seems, at least at times, to suggest the other option that I left on the table for you to pick between, saying that appellees have not asserted that long-arm jurisdiction would violate the First Amendment. They're free, however, to raise a First Amendment argument in the trial court, which makes it sound like what would need to have been done on remand in Rose would have been not just to say this is petition activity, but instead to say that imposing jurisdiction over me on the basis of that offends the First Amendment. But that's not how you read the cases in this area as a whole. Is that correct?
That is correct, but looking to the actual holding of Rose, what we understand this as is that the core issue is that that party raised primarily due process and fairness-based concerns in their 12b2, where they mentioned the government contacts exception. So that remand, the core issue was to discuss whether that defendant's contacts with the district fell within the First Amendment, or to quote the language of Rose, offend the First Amendment. And the issue is that the party failed to address that altogether, and that was the basis for the remand in light of the court's articulation of the exception scope, because the First Amendment provides the only principled basis for the government contacts exception.
If that's, sorry, Chief.
I was just gonna ask, would you be making the same argument if we were sitting en banc today? In other words, do we need a government contacts exception when our District of Columbia long-arm statute already builds in due process protections? Is it a redundant analysis? I mean, if we're looking at whether the entities here, the universities, were transacting business in the District of Columbia, and therefore we had jurisdiction over them, why shouldn't the analysis stop there? Doesn't that provide sufficient protection under the due process clause of the Constitution from inappropriately hauling in defendants before our DC courts?
It is not a redundant analysis under this court's holding in Okmeshkin versus Browder that occurred 3 years ago in 2022, where the court looked at due process concerns as a separate constitutional threshold to the assertion of jurisdiction that is separate from the government contacts exception. And this falls in line with this court's holding in Environmental Research versus Lockwood, more specifically looking to page 813, footnote 11, where the court mentioned that the only reason why the government contacts exception survived the passage of the modern long-arm statute in 1970 that resolved the existing due process concerns was because of the continued viability of those First Amendment concerns. The court even quoted a Fifth Circuit case that stands for the proposition that even when you have a broad, far-reaching long-arm statute like the one in DC that gives jurisdiction to the full extent as allowed under the due process clause, that assertion of jurisdiction must yield when it poses a threat to the free exercise of First Amendment rights. And that idea, although it wasn't part of the holding in Lockwood, was made explicit 2 years later in Rose when the court needed to articulate a proper scope for the exception, and has been re-emphasized by this court on multiple occasions since 1978.
But looking at and taking it a step further, and now looking at what's happened in terms of the Supreme Court's decisions, if you agree, as you are arguing, that the government contacts exception is limited to the First Amendment, what or would that conflict with the Supreme Court's recent or relatively recent decision in Calder v. Jones, in which they tend to say that's double counting on whether that's an appropriate contact or not, and should not be considered as part of that inquiry, that the First Amendment no longer serves that purpose. I
Here,
mean, that government context exception no longer serves the purpose because, again, it's, the First Amendment is not offended by that, under a typical long-arm statute analysis, going to what the chief was talking about.
and that's why we focus specifically to whether an activity falls within a First Amendment activity rather than a plain violation of the First Amendment, because we're not looking to whether the First Amendment has been offended, but rather whether the assertion of jurisdiction would pose a threat to the free exercise of First Amendment rights. For example, looking to the last right in the very last phrase of the First Amendment, the right to petition the government, it only makes sense that the place where our federal government sits is a key place where out-of-state defendants would come to exercise that right, to petition the very government that sits here. And that is the basis for the government contacts exception, to promote free exercise of that right without parties thinking that they're going to be hailed into DC's courts merely for petitioning the government for redress of grievances, which was the very right that was quoted in that same footnote 11 in Lockwood.
Well, it would certainly substantively violate the First Amendment if someone were hailed into court on the ground merely because they petitioned the government, meaning that that was the gravamen of the cause of action. But if someone who is here to petition the government ends up, having a traffic accident and is hailed into court for circumstances arising out of their trip here, it is less clear whether that is a violation of the First Amendment or is a burden on the First Amendment that ought to affect the interpretation of jurisdictional statutes.
The example that you just provided would be dealt with a due process inquiry, because, for example, if they suffered a traffic accident while they were here, that's not necessarily arising out of their contacts with the district, because it's not arising out of them actually coming in and petitioning the government. That's a separate issue where they just so happened to get into a car accident while they were here. And that kind of mirrors the issues with Morgan and Stevens, the universities raised, which are two cases with similar contacts with the district. It was universities engaging with the federal student loan program. But the issue there was, again, on due process grounds as well as under the long-arm statute. It did not arise out of their contacts with the district for the plaintiffs to assert claims based on breach of contract for a discontinued major, or in Stevens, the issue was about poor education quality. But here, what we have is a dispute about these loans, and the contact is also the contact that allowed the universities to engage in the federal student loan program that led to these debts being fraudulently created in Ms. Najai's name.
So petitioning the government and doing business with the government, going back to my government contracts analogy, I'm still a little fuzzy on where you draw the line, because parties can be doing both, doing business with the government, or coming to learn how to do business with the government, or to gain additional contracts with the government. How about that? Someone who already has a contract with the government coming to learn about doing more business with the government. If you have mixed purpose, I guess, does that automatically mean that the First Amendment purpose overshadows any other purpose?
This analysis seems to be a contact by contact inquiry. So the party coming in and forming that initial contract would not fall within the First Amendment and would not be carved out of the jurisdictional inquiry, but perhaps them coming in and merely petitioning the government or soliciting more information after that initial contract has already been created. It is possible, depending on the facts of that case, that that contact would be carved out of the jurisdictional inquiry, and the only other basis that the court could lean on to see whether there is sufficient contact with DC to assert personal jurisdiction over that party would be that original contact, the formation of that contract with that particular agency.
So how would you answer, I guess, in closing, I know you've reserved some time for rebuttal, but how would you answer or suggest that this court answer the two questions certified from the DC Circuit?
We would suggest that the first question certified be answered in the affirmative, that this court hold that the government contacts exception is limited to First Amendment activities. And turning to the second question, this court should hold that the university's activities fell outside of the First Amendment scope such that the exception cannot apply.
And fell outside of the First Amendment scope. Why?
Fell outside of the First Amendment scope because they get engaged in for-profit commercial operations within DC, which falls outside of the First Amendment, looking to the line drawn in Fandel versus Arabian American Oil Company in 1965 by the DC Circuit.
Thank you.
Thank you.
And remind me again, will both counsel be arguing or just, okay?
Thank you, Your Honors, and may it please the court. Natalie Selmanowitz for Appellees, New York University and Long Island University. The government contacts exception provides that if a non-resident defendant's alleged activities within the district consist solely of contacts with the federal government, those activities are not transacting business within the meaning of the long-arm statute, and personal jurisdiction cannot attach.
Can I interject there? And focus you on my government contracts or contractor analogy. If you're a government contractor and your contacts, and you're here in the District of Columbia, your contacts are solely with the federal government, solely for your government contracting commercial business, where does that fit in your description?
Great. So we disagree with amicus that there's any sort of commercial activities exception to the government contacts exception, and that's for a couple reasons. First of all, it just can't be right under environmental research or Mueller-Brass. Environmental research, the government contacts there were seeking a grant from the EPA to help build a textile factory. That's a commercial operation. And same with Mueller-Brass. There it was basically a company selling parts to the government for use outside of the district.
But this would seem like now, given the increasing, I would speculate, number of folks contracting with and doing business with the federal government as compared to the 1970s when Rose and environmental research were decided. It would shield a lot of folks from being brought within the jurisdiction of the courts here in DC, even if they were only doing business. They weren't petitioning the government. They weren't exercising a particular First Amendment right with the government. They were doing business with the government as they might do business with Google or Lockheed or any other company that happened to be located here.
So there are a few answers to that, Your Honor. First, I don't think it's true that you're necessarily going to see businesses shielded under today's version of the long arm statute because we're only dealing with subsection A1, which is transacting business. If a business is dealing with the government and entering a contract to supply services for things in DC, that's going to fall under A2. And there's all these other statutory bases.
So are you saying you don't think there's a government contacts exception to A2?
This court, I believe it said in Ahmedson that the only statutory basis in which this court has recognized a government contacts exception is with respect to A1.
That's true, and we didn't recognize it in A4, but I don't know that we expressed a view, maybe we did, I'm not recalling, but I don't recall that we expressed a view about what the answer would be under other subsections. So it's like, they've always been A1 cases in this court, like the DC district courts and the DC circuit had applied it in other subsections. But we declined in Ahmedson to apply it to A4, but your answer seems to presuppose that in fact there is no government contacts exception for A2 either, because if there is one, then your answer isn't any assurance. So are you conceding that there is no government contacts exception to A2?
Not necessarily conceding that, Your Honor, but I think there's good reason why it would apply in A1, but not necessarily A2. The reason why it applies in A1 is because the phrase transacting business is so broad that it can easily sweep in companies that have no contact with the district other than dealing with the federal government. And that's exactly what happened.
I get that concern, but couldn't it be addressed by interpreting it to not sweep in things you shouldn't sweep in, but sweeping in things you could sweep in, including things that would also fall under too, like contracting to supply services?
I'm not sure I fully.
Well, yeah, I mean, you're saying there's a reason to have a government contacts exception in A1 because A1 could reach more broadly to things that would be problematic. And I guess my question is, one way you could deal with that is have a government context exception. Another way is you could just interpret transacting business so as to include certain, whatever is, what might be problematic, wouldn't include that. So again, if the claim supposedly arose out of what you said when you were speaking to a government official, and that was your only contact with the district, well, maybe you wouldn't call that transacting business because it might not intuitively seem like transacting business and because it might be problematic to do so. But you could take transacting business otherwise generally to, for example, apply to some definition of commercial contacts between the putative defendant and the government. So I'm just not quite sure why the idea that there might need to be some limit on the idea of transacting business supports the idea that there can't be a commercial, that all contacts with the government, no matter how commercial in character, are governed by the government contacts exception. I just don't see that they quite follow.
So I don't think that a commercial activity exception is present in the case law. And that's what I was saying about environmental research or Mueller, Brass, and Fandel, the case that Amicus mentioned, actually doesn't provide any commercial exception itself. If you look at that case, it's just saying that Washington, D.C. presents businesses with a need to be in D.C. in order to engage with government that's different from other interactions with non-governmental facing entities.
Can I ask you, so your answer about the idea that if you read A1, the government contract exception under A1 broadly to apply to all contacts between the putative defendant and the government, that wouldn't necessarily create kind of impunity because A2 might step in. A2 is about contracting to supply services. So let's say that I have a business that is located in Virginia and I enter into a contract with the government to sell widgets to a government agency that is located in DC. And the contract says for delivery in DC. And then I breach that contract. I never send anything to DC. Well, that's not contracting to supply services in the District of Columbia. So A2 wouldn't help. It's not a tort. So I'm not sure that like A3 and A4 or A5 or A6 or any of the provisions would apply, nor does it seem to me that the general jurisdiction provision would necessarily apply. So if really the government context exception excludes all claims that are predicated entirely on contacts between the putative defendant and the government, it seems like that would be, you just couldn't sue somebody in the district for that. Now, maybe you could sue them in Virginia and maybe you think that's fine, but I don't see how you sue somebody in Virginia in DC on that hypothetical on your theory. Do you agree with that or do you have a different response?
So if I'm following the hypothetical correctly, it's that there's a contract for the sale of goods in DC, but you don't actually end up delivering anything into
Correct.
DC.
And you're being sued, and the government wants to sue you for breaching the contract. And the government is in DC saying, this is a contract to deliver goods to me in DC. It was breached. DC is a perfectly natural place. The due process clause certainly wouldn't be offended, nor is that First Amendment activity in any normal sense of that term. Why would you interpret the government context exception to preclude suit in DC? It just doesn't seem obvious to me why you would.
In that circumstance, though, if it's a breach of contract that occurred in DC, it sounds like you would have an injury in DC, which would fall under some of the other statutory.
Those are
cases.
tortious. I mean, those are causing tortious injury or for 3 or 4. So that's a contract claim, not a tort. So I picked that hypothetical for that reason.
Well, in that case, I think it still depends on looking at the particular purpose of the contacts at issue. And if it is just dealing with the government, then that's not going to count. If it extends more broadly, then the government contacts exception is only going to take out of the jurisdictional calculus those contacts that involve exclusive dealings with the federal government. And the reason that this rule exists is to supply a bright line rule that's easy for defendants to predict and easy for courts to apply. And I'd like to point out that
Sorry to interrupt, but that just triggers a reaction, which is the fact that the DC Circuit has certified 3 times to this court what the exception means gives me some pause about the idea that the government contacts exception, as we've been applying it, is a bright line rule that is easy for everyone to apply. The DC Circuit certainly hasn't found it easy to apply. They keep asking us what it means. And I'm not faulting them because I think they have good reason to be curious about how to reconcile our cases.
So I think the DC Circuit has sometimes had trouble reconciling the cases. But I would note that district court after district court in the District of Columbia routinely applies the government contacts exception as articulated in environmental research, since that's the en banc decision that controls. And under environmental research, you just ask one question. Are the contacts alleged in the district solely activities with the federal government? If yes, then those do not enter the jurisdictional calculus and personal
For
jurisdiction.
A1.
Very well.
For subsection A1. they
For
make it
subsection
other
A1,
subsections.
exactly.
Can I ask you, you started off by saying we're here interested only in A1. And Ms. Njai seems to indicate that in her view, the jurisdictional question that was presented in federal court was not limited to A1. Do you disagree with that and think that the certified question did not zero in on A1. It said under District of Columbia law, as I recall. So I just want to make sure I understand what it is that leads you to say that you think the only issue we need to be thinking through and answering that question is how to understand how the exception applies under A1.
First, Your Honor, we would read the certification order as limited to A1. It routinely talks about A1, page 3 of the order cites A1 specifically.
Well, are you talking about the opinion, the order itself? There's a certification order and then there's an opinion or order related to it. So there's like a one-page order that is in accordance with the opinion. It is ordered that the following questions be certified. And
Okay.
that one-page order just says under District of Columbia law is the government contacts exception limited to First Amendment activity. Now there's the opinion it does, so I mean, the opinion does say this case concerns subsection A1. That's on page 3 of the opinion. That may be where you're getting to.
Right.
But I'm just wondering whether is that because that's how it was briefed in the district court and how it was briefed in the circuit. And so in your view, we should understand the certified question in that context, and that to the extent appellant is trying to suggest broader theories, those are too late? Or what is it what's the procedural context that you think led the circuit to, on the one hand, certify a question that wasn't expressly limited to A1, on the other hand, wrote an opinion that does say that they're focused on it?
Right. So in the district court proceedings below, the plaintiff raised other statutory bases for jurisdiction. In the district court's opinion dismissing the complaint against the university defendants on personal jurisdiction grounds, the district court focused exclusively on A1 and the government contacts exception.
That would be a mistake then, wouldn't it? If the plaintiff says, I have 3 reasons why there's jurisdiction, and the district court judge said, I'm assessing one of them and I don't find it a valid reason and I therefore dismiss. It seems like the district court would not have fully addressed the claims that would have had to have been addressed in order to support dismissal.
So my understanding is that in the amended complaint below, the plaintiff, when she was addressing other statutory bases for jurisdiction, had conclusory allegations. A lot of it looked like just citing the text of the statute and then saying this was met here. And so I don't think the district court was under an obligation necessarily to deal with those conclusory allegations. But as this case comes to this court, I do think that A1 is the only statutory subsection at issue. And it is largely because the certification order talks about transacting business and how the long arms and how the government contacts exception has been understood to apply as an interpretation of that particular provision. So I do think we are dealing with A1, and that's also the only subsection at issue in environmental research and Rose. And the certification order arose out of this, there was a conflict between environmental research and Rose. And so I think that naturally suggests that A1 is what is at issue here, since both cases were fundamentally interpreting A1, the transacting business prong. But to get back to the notion of why this is a bright line rule, because I think Your Honor had some questions about that.
Why it is or why it isn't?
Why it is.
Mhm.
So the government contacts exception deals with prudential concerns by applying this bright line rule that under environmental research directs courts to ask, what are the contacts in the district alleged by the defendant? Are they just dealing with the federal government? If so, those do not enter the jurisdictional calculus. And that's a really important bright line rule. A, because it helps courts quickly dispose of cases that have little bearing to the District of Columbia, like this one. And two, it also
Why
is an
do they
important.
have little bearing? I mean, in the hypothetical I gave about a contract to supply goods in the District of Columbia, that seems to have plenty of bearing in the District of Columbia. So they may or may not have a lot of bearing depending on how extensive the contacts were and what the nature of those contacts were.
That's true, but in many cases, you're going to have a situation where they're not going to have a big connection. Let me give you an example.
Can I ask you just to, I mean, I take your point that that may well often be true. So I'm with you on that empirical hypothesis. But can you, part of the reason I was asking, even if this case does not squarely require us to assess the applicability of the government contacts exception to any subsection other than A1, and figuring out how it operates with A1 or how to reasonably construe it, I think is relevant to understand whether it applies to the other subsections and whether what that means about the reasonable scope of it under A1. And so I guess I'm just trying to understand the logic of saying the right way of interpreting the long arm statute is that there's a bright line rule about A1, which is all government contacts, whatever they are just out of the picture. But then we have all these other subsections, A2, that says, oh, transacting business with the government in the District of Columbia. I mean, I'm contracting to supply services to the government in the District of Columbia. Well, that's in. Tortious injury, under Ahmedson, tortious injury in DC under A4, that's in. So that's a contact. So there's a bright line rule under A1, they're all out. But then various of the subsections pull them back in various ways. That seems a little, I don't know, odd. Do you see why that seems, it just seems odd to have a sweeping bright line rule about one of them that is inconsistent with the idea that those same contacts are freely considered under maybe A2 that we haven't decided. I'm not sure you've expressed a firm position on. Definitely not A4 because that's what we held in Ahmedson. Is that a sensible set of considerations taken together?
I see my time is up. Can I answer? Two answers to that, Your Honor. First, as you go down the list of statutory bases for jurisdiction, each secondary, third, fourth basis has inherently more activities in the district. So in those cases, it's a lot less likely that you're going to sweep in a defendant whose sole contact in DC is this interaction with the federal government. Because in A4, for example, they're going to have cause of tortious injury here. So that's one answer to your question. The second answer, insofar as you're asking about why there's a bright line rule here, whereas in other situations, it's a lot more fact intensive. Those types of bright line rules exist all the time. And I'd point this court to Justice Breyer's decision in Hertz versus Friend, where he talks about the virtue of administrability when you have jurisdictional statutes. And that's important first because of preserving judicial resources, especially in a situation like this, where you could get cases involving federal programs where, like, if you take student loans, for an example, there are 6,000 universities across the country who are eligible to participate in the federal student loan program. And so if you didn't have the government contacts exception, all of those universities could theoretically be hailed into DC court on a claim related to student loans in some capacity just because of this one contact. So the government contacts principle allows courts to quickly dispose of those cases.
Well,
It's
but
also
doesn't
really
the due process protections, don't the due process protections that are baked into our long arm statute help avoid the situation that you're describing? Any contact with the mere contact of any kind with a federal agency automatically carves out this exception that takes you outside the parameters of the long arm statute. I hear your concern about sweeping in federal agencies or universities who have this one type of contact that's fairly limited with one federal agency, but aren't the due process protections supposed to avoid or help us avoid the situation where that one university gets pulled in for this minor federal contact, which seems to me to be very different than what we have arguably under the facts here, where there were, I'll use the amicus's word, there was an engagement and procurement of loans and commercial activity beyond just going up to say hello to the administrator of the Department of Education. So it seems to me that carving this out as such a bright line rule without any examination of what the contact is with the federal government is overly broad. And the harm it seeks to protect against is protected by the due process provisions of our long-arm statute. How would you respond to that?
So there are a lot of questions baked in there, so I'll try to address each in turn. First of all, this court, or your honor, asked about why the due process clause isn't serving as a sufficient backstop. Part of that has to do with the fact that, as environmental research pointed out, minimum contacts is a pretty flimsy inquiry in some instances. It doesn't take that much to be considered having minimum contacts. Second, the government contacts exception does serve as this predictable protection that avoids having to go into that analysis, because as courts often say in the federal district courts, when you are dealing with contacts that are solely related to the government, those just don't enter the constitutional calculus. So you're not having to decide in each of those situations whether the minimum contacts have been satisfied and whether traditional notions of fair play and substantial justice have been satisfied. And that, the constitutional reasonableness inquiry, that's a 5-factor test that gets away from this administrable rule. But to your question about the facts here, this is indeed a case where the only contact with DC alleged is this supposed contractual relationship with DOE, because this case is really about some loans that apparently were fraudulently signed by NYU and LIU on behalf of the plaintiff. And the allegations suggest that that happened in New York, because it says where those loans were originated or something to that effect. And there's no allegation in the complaint or the related pleadings talking about the universities coming into DC or them doing anything in DC besides this contractual relationship. And we don't really know what this contractual relationship entails. All we're told is that it's a contractual relationship regarding her student loans with DOE. And one other point I'd like to make is that the entire colloquy you had with amicus about the nature of the First Amendment activities and how to decide whether First Amendment activities are at issue here or not shows why the First Amendment is not a limitation on the government contacts exception, because otherwise, instead of quickly disposing of these types of cases and funneling them to a court where they're more properly heard, or to avoid the situation where asserting personal jurisdiction over a defendant solely for their engagement with the government would disincentivize them to continue participating in a federal program.
But isn't that why this government contacts is an exception to 1A transacting business? The trouble I think I'm having conceptually with this very broad sweep, any contact with the federal government takes it out of the long arm analysis, is because the rule is, or the provision that we're supposed to be looking at is transacting business. And if we don't even apply any level of scrutiny about whether business is being transacted, we just say it's a federal contact, we're not going to look at it. Isn't the exception overtaking the rule? I mean, it seems to me you have to look at, is any business being transacted here with the federal government? And if it's not, okay, then we can take it out of here as a government contact. And it would fall within the narrow exception, as opposed to this narrow exception basically wiping or setting aside the rule.
Yeah, so it's the plaintiff's burden to allege specific facts establishing jurisdiction over each defendant, and the plaintiff can go through whatever statutory basis of jurisdiction it thinks is appropriate, but then the plaintiff has to allege sufficient facts to show that it comes, if they're invoking A1, that it actually comes within the transacting business language in the first place. And then the question is, okay, if you're in A1, is that just the type of government contact that we're dealing with in environmental research, and environmental research says that's not enough and it's not going to count for purposes of deciding whether something is transacting business under the long arm statute.
So you don't read Rose as in any way modifying environmental research in that regard? Because Rose would suggest that if you look at it, if it's government contact, bright line, it's out. First, we do our transacting business minimum contacts analysis under our long arm statute, correct? And then we can apply the government contacts exception to determine whether government contact itself has any connection to transacting business and therefore should not be considered, right? Or should be thought of differently in terms of establishing minimum contacts to establish jurisdiction. What's wrong with that approach?
We would read Rose differently, Your Honor. So, and I'll acknowledge it is slightly confusing because the term government contacts exception or government contacts principle is used quite loosely throughout these cases. But as we understand Rose and looking to the language in Rose itself, we think Rose was asking a different question. So in environmental research, you're dealing with a situation where the only contacts with the DC, with the district alleged are these government contacts. And so those don't count as transacting business and you're not going through the minimum contacts inquiry. The analysis is done. And since A1 was the only thing asserted there, personal jurisdiction can't attach. In Rose, you're dealing with a situation where there are sufficient other contacts such that even if you took out the ones related just to the government, you still have to go through the minimum contacts due process inquiry. And Rose says, in a situation in which the contacts are sufficient to qualify as transacting business under the long arm statute, and asserting jurisdiction would be consistent with due process, then is there then nevertheless a basis to exempt that person from personal jurisdiction because some of their contacts involved government contacts. And that's where the First Amendment comes in under Rose.
I'm not sure I understand your answer. Are you saying that you think the way you read Rose did what you think of as the ERI/Lockwood government contacts exception analysis and said, and use that to set aside anything that would be viewed as a contact with the government, and then said there's enough here to be okay, and then said, but we're gonna then have another inquiry that is the First Amendment government contacts inquiry that's gonna be conducted on remand? Because I didn't really read the opinion as doing the same government contacts inquiry twice, one the ERI type and the other a First Amendment type.
So what Rose did was it looked at the contacts at issue, and it noted that the contacts at issue were substantially different from the contacts at issue in environmental research, because the only contacts attributable to the defendant in environmental research were these 2 meetings with EPA officials about a grant. In Rose, the contacts at issue, their purpose extended much broader than just meeting with the government. So you had the defendant transacting business with the plaintiff to give him a salary to move into DC, to have an apartment in DC, to set up shop, to potentially file a suit against the government in DC. And in that case, the parties conceded, as Rose noted, that there was no reason to have an office in DC or to actually use the DC courts for this potential suit. So those are all these extra contacts that would fall outside the government contacts exception and under environmental research under that framing. And so Rose, as it noted, was asking a different question. But
let's say I don't read Rose that way, and that gets me to one of the aspects of the cases that's most significant to me, which is if one thinks that Rose interpreted Lockwood or ERI in a way that might not be the way as an original matter one would have. And let's say one is a judge, hypothetically. What do you think? It's been an assumption of your brief and an assumption of your argument today that if there's a conflict between them, that a judge in this case would perceive that the court would be bound by Lockwood and its understanding of itself, rather than kind of Rose's interpretation of Lockwood. And I guess I'm just not sure whether I think that's right or not right. So can you ask me, at the highest level of abstraction, assume that there is a case number 1 that is binding on case 3. and it says a bunch of things. And then case 2 comes along and the judges in an equally binding decision say, here is how we understand case 1. And then the judges in case 3 have to look at case 1 and case 2 and figure out, what to make of them. And let's say the judges in case 3 look at case 1 and say, it's an original matter, we would have read it differently. We think it means something slightly differently. As an original matter, that's what we would think. But case 2 came along and in an equally binding decision or a binding type decision, ordinarily binding decision, has said, no, case 1 means something different. Which do you think is binding on the judges in case 3? Their own the case 1 as they now interpret it as an original matter, or instead case 2, which looked at it and on behalf of the judges who have authority to do that, interpreted it to be something perhaps different than what the judges in case 3 would think. It's just not obvious to me which is binding or why you assume that if there's a conflict, what's binding is our current assessment of how we would read case 1 here, ERI/Lockwood.
So environmental research was an en banc decision, and Rose.
I mean, there are no, sorry to interrupt, but just to say one thing about that is, I mean, whether it was a decision of a division or en banc, it's equally binding on us and was equally binding on the division. And we don't have as far as I know, we don't have a rule that says if there's a conflict between en banc decision A at case, the earliest case, and a division decision interpreting it, the en banc decision rule is governing. Now, maybe that's a principle you're advocating for, but they're both binding on us.
Your Honor, I think in Judge Gallagher's decision denying rehearing en banc in Rose, he said something to the effect of a 3-judge panel is powerless to issue a decision that conflicts with a prior en banc decision. And so here, I think
Right, that was the concurrence of Judge Gallagher, so it doesn't say the rule of law for this court. And again, it's true as far as it goes, but again, and I understand that line of thinking, but just to flag the other approach to it. If you take the view that decision B can never change the interpretation of if let's say decision A is binding on, back to A's and B's and C's, sorry, than 1s, 2s, and 3s, but let's go back to 1s. So decision 1, a binding decision, it says whatever it says. If you think that whatever it says is binding on later judges in case 3, only in the way that those judges have to figure out for themselves as an original matter what they think decision 1 means, and they're bound by their current understanding of what decision 1 means. Even if in between decision 2 looked at the same thing and said, here's how we interpret it. If there's a difference between how the judges in decision 2 would have interpreted it and the judges now in decision 3 would interpret it, if it's always you go back to the original opinion and you do what you think it means rather than what your colleagues in a binding decision have said it means, that's a very unstable approach to precedent. It means there's no binding precedent interpreting prior precedent, because whatever later judges said that precedent meant, if that original precedent was also binding, what's really thought to be binding is the current views of the judges about whatever they think that first opinion meant. And I just don't know that I think that it's clearly established that that's the right way of looking at it. I don't think it's clearly established it's the wrong way either. It just seems to me like an unsettled, difficult question.
Your Honor, we've tried to provide you a harmonious reading of environmental research versus Rose that would avoid a lot of these questions, but environmental research remains the en banc decision. So to the extent that Rose added any gloss onto environmental research or interpreted its scope differently than what environmental research set forth, Rose had no power to do that. And we do think that—
Well, it wouldn't have had any, I mean, in one sense, it wouldn't have had any power to do that, whether Lockwood/ERI/Lockwood was a division decision. A decision of a division is binding on subsequent divisions. And so whether Lockwood was en banc or not, it would have been binding. And on the way of looking at it that you're advocating, Rose can't change that. And whatever Rose says about what Lockwood means is really irrelevant, because later decisions just have to figure out what they think Lockwood means. And Rose can't change it. So who cares what we think of it? Who cares what Rose thought Lockwood meant? We always just go figure out what we think Lockwood means. I mean, that's a possible answer. It just seems like it's an answer that would have some surprising consequences. So I'm not sure it's the right answer. I'm not sure it's the wrong answer, to be very clear, but I'm not sure it's the right answer.
Let me try rephrasing it this way. If you agree with our harmonious reading of the two cases as asking different questions by looking to Rose itself and the question as it framed it versus the question as environmental research framed it. I don't think you have to engage with this at all. But what I would say is that the text of environmental research is pretty clear. It contains no First Amendment limitation. When it articulates the test and how to apply it, it's not asking at all whether the activities at issue involve First Amendment activity or not. And when describing the reasons underlying the rule, it notes the First Amendment for sure, but it also goes on to articulate these prudential considerations, such as the need to avoid turning DC into a national judicial forum.
So should we be concerned that Rose doesn't address the prudential concerns that environmental research identified? And does that in any way mean that Rose was misinterpreting environmental research?
That is one argument. You could also say that because Rose was dealing with a second order application of environmental research, that the prudential considerations at that point weren't as important once you've gone through the minimum context due process inquiry based on the other contexts at issue. But the prudential considerations really are what the bright line aspect of the government context exception is all about. And those prudential considerations are just as important as they were in 1976 when environmental research was decided as they are today.
Are they though? I wonder in the modern world where technology sort of blurs a lot of lines, transportation and travel is a lot easier. So arguably, maybe it's not as big of a hardship on a defendant to be hauled into court in the District of Columbia based on some contacts here with the federal government, as it was in 1976 or 8, I forgot, when, I think it was 6, when environmental research was being decided.
So the prudential concerns are, one, that you're going to risk potentially opening the floodgates to cases that have minimal connections to DC, like this one, or I can give some other examples
Well,
in a
but we
moment.
haven't necessarily seen a floodgate, have we, since 1976, for these kinds of cases?
If you look at the district court dockets, there have been a ton of cases involving the government contacts exception. Everything from a defendant buying a home in Louisiana pursuant to a HUD foreclosure sale, and the alleged contact there with the district was just this sales contract with HUD. That's where the government contacts exception comes in. Federal grants, student loans. We've had 2 student loans cases in just the past couple of years, Morgan's and Stevens. There are all these types of cases where plaintiffs try to base their jurisdictional hook on this participation in a federal program. And so, yes, I think those concerns are just as valid today, in fact, even more so than they were in environmental research. And the other prudential considerations
Go ahead.
at play are these comedy-based considerations about hearing disputes that really don't belong here, and also the idea that if you assert personal jurisdiction over defendants solely because they engage with the federal government, that you're going to disincentivize defendants from participating in these programs in the first place. And that was a concern that environmental research highlighted when it said that the government context exception is needed to encourage free public participation in government.
You know, in
So-
response, sorry.
I had one
ahead.
last question on this, along this line, is if we were sitting en banc today to look at these issues, would you frame a different rule, or would you still be adhering to the rule as you're articulating it, as you view ERI having articulated it?
We think it's an important rule that, because of these prudential considerations, still has a lot of force today. So even if you were deciding afresh whether to have a government contact exception, yes, we think it is necessary, and that the bright line nature of the rule does a lot of work, both from the court's perspective, but also from giving defendants ex ante certainty about the fact that if they come to the district just to engage with the federal government for some program, that's not going to hail them into DC court. And so for largely the reasons I just noted about how the prudential considerations then apply now, we think that the government context exception is still valid.
You know, in response to that, council today has raised an issue that was raised in Mitchton case, talking about forum nonconvenience. Why isn't that an adequate remedy to address the concerns you raise here about the prudential concerns?
So Ahmedson was an A4 case. And so already that's different than A1 because when you're dealing with A4, you have to be assessing whether the defendant has engaged in a persistent course of conduct, whether the conduct at issue occurred outside of DC versus inside DC, where the injury occurred. And so you're already in a realm where a bright line rule isn't going to be doing that much work. But in A1, if you punt all the questions of these prudential considerations to forum non-convenient, you're upending the entire bright line administrable nature of the rule. Forum non-convenient is a 12-factor test that courts have to go through. So that's not only going to substantially increase the burden on courts, but also remove the certainty of the government context protection as it exists in A1.
I know you're over time, but just to, and I don't want to generate a long discussion, but I want to, in a nutshell, if you could explain, I know your position is that the answer to the first question should be the government context exception is not limited to First Amendment activity, whatever that means. But assuming for a moment that the court answered that question differently, in a nutshell, could you explain how you think the second question should be answered, again, assuming contrary to your position that the first question was answered in the affirmative?
So two components to this, Your Honor. First, we don't think the second question is adequately teed up for this court's review because in order to decide whether the contacts at issue involve First Amendment activity, you have to have a solid understanding of what the contacts are. And here, all we know is that there's a contractual relationship between the university defendants and DOE regarding her student loans. We don't know in what way they're regarding her student loans. We don't know what this contract entailed. And without those types of details, you can't really assess whether this involves a First Amendment or not. I will say it's possible from her allegations that she's talking about this program participation agreement that every university participating in the federal student loan program has to enter with DOE. And if that's the case, although it's not entirely clear that that's the case because that involves student loans generally and it wouldn't be regarding her loan specifically. But if you think she's talking about this PPA, we think that that actually would implicate the First Amendment because in order to be in the situation of having a PPA signed, universities have to apply to the federal government to be able to participate in this program and have to submit a bunch of information and certifications. And so that is not that different than asking the EPA for a grant. And I'd note that in federal district court, at least one court has held that filing registration statements with the SEC to become an investment company counts as petitioning the government in commercial speech. And so we think if this court were to rule against us on the first question, get to the second question, decide to engage with it, then there is some First Amendment activity here.
A last complication about that topic. If hypothetically the first question were answered in the affirmative, so that the whole world is First Amendment activity, there's, I don't know that the parties have much focused on this, but in some of our cases, including Ahmedson, there's discussion of Supreme Court case law, including a case called Calder, where the Supreme Court seems to have said, with respect to federal jurisdictional statute, that to the extent federal courts there were kind of putting a First Amendment gloss on a jurisdictional statute to protect First Amendment interests, that was kind of I don't know if this was their word, but that was a misguided enterprise. And really the First Amendment doesn't require that, and that shouldn't be done to statutes. Are you familiar with that case law, and do you have any comment on how it might apply? Again, if one were to interpret the government context exception is in some sense limited to First Amendment activity, whether Calder would mean that if it is limited to that, it has no remaining function because the Supreme Court has said that there's no need for these kinds of doctrines to protect First Amendment interests. Are you familiar with that case, and do you have a response, or is that, I know the parties haven't really zeroed in on it, so you'd be well within your rights to say that hasn't really been teed up well.
Yeah, I'm only vaguely familiar with it, but what I will say in response to Your Honor's question is, one, I think that entire exchange underscores why the government contacts exception shouldn't be limited to First Amendment activity, and it underscores environmental research's emphasis that this isn't just about the First Amendment activity. Isn't just about the First Amendment anyway. It's about these other prudential considerations.
Are those the only two reasons? You said this the dialogue about the Calder case underscores why the government contacts exception isn't just about First Amendment. What else is it about other than prudential concerns, and what else?
So the government contacts exception is rooted in both the constitutional First Amendment concerns and these prudential considerations, those being the risk of opening the floodgates, hearing cases that aren't appropriately heard in this forum, and deterring participation in federal programs. If you're going to be asserting jurisdiction just on the basis of these sole government contacts.
And included in that, you'd add comedy, so that we're not overburdening our courts in the.
Exactly. I
in the
think
federal
comedy
court.
is a angle of multiple of those in terms of that DC is not the appropriate jurisdiction to hear certain cases, and comedy with respect to the federal government so that you're not stepping on federal programs' toes by making it harder for people to be willing to participate in light of jurisdictional consequences in DC.
Thank you.
Thank you.
All right, Ms. Njai, you have a few minutes reserved for rebuttal at this time.
Yes, two things come to mind. The only, excuse me, the only thing that's flooding the courts are these servicers and these institutions who are capitalizing and receiving millions of dollars from the District of Columbia by fraudulently claiming that that student loan borrowers somehow owe them more money, more money than they even borrowed in interest fees and cost and different things so they can get a monthly check. But real quickly, there's a counter in the Facebook thing that the reason why the district court accepted, granted a long arm statute. One of the factors was that Facebook's contact within the district was purposefully established and functioned as a storefront in the district on the grounds that Facebook acts and contact constituted continuous and systematic business transactions. B, a widespread exchange of maintenance and consumer personal information through Facebook's networking service led to adverse effects within the district. And this is the one that relates to what she was talking about. Due to Facebook's repeated filings with federal agencies or the Department of Consumer and Regulatory Affairs, the DCRA, as a foreign corporation who operated offices in DC and acquired revenue from DC, all constituted business transactions within the state for purposes of establishing personal jurisdiction. It's the same thing that if you look at my case or this case where the universities and these servicers are engaged in their exchange and maintenance of consumers' personal information. That's how they was able to take my actual student loans for $5,500 and change it into a $66,000 debt by taking my personal information and altering it. And it was through a federal agency. So why would they grant in Facebook personal jurisdiction on the basis that they were dealing with the federal agency? That was one of the aspects. If the university can now come and say that any engagement with a federal agency is is a basis for dismissing the case. Another issue was in Rose, it was whether it was an independent contractor or an agent. we're not looking at the quality or what the elements were in the contact itself, the quality or the kind of actions that they interact with Doe. We're looking at, they want you to just look at the fact that they was broadly dealing with a federal agency, claiming that it was just some incidental versus purposeful interaction. So those two key words bring to my mind whether it's concerns of federal First Amendment issue or not, whether it was purposeful or whether they were independently doing their business separately from Doe, or whether their whole basis or contract relied on servicing Doe's federal student loan program. And also in Facebook, the district didn't just include the defendants, they included national student borrowers from DC that wasn't even in the case. You see what I'm saying? So when you're talking about, here comes these people who are making, for example, I have in my hands where it was federal awards. FMS got $284 million from Doe. That was in 1 year alone. These are the kind of contracts that these people, the institutions and the servicers, collectors are getting from DC. They're collecting major benefits and protections based on their information that they give to Doe. So if they go to, and they use Facebook 99% online as a storefront to doing business for in DC, whereas in the NYU and LIU and all them, they have to daily, 24/7, they have access to databases of Doe doing business systematically in DC. You know, I didn't, you know, they didn't garnish my Social Security in New York. They garnished my Social Security in DC based on the information that they put on these databases in DC. And they're still threatening me even after they dismissed most of them. They don't have master's promissory notes or anything that I signed for additional money. They even kept my payments where I paid off the loans and won't say anything about it. They won't accredit it. So it's not just a matter of them just having this incidental relationship with Doe. It's more than that. And that's what brought me to the point where I can't understand. It needs to be a broader like test. Like
All right,
if
Ms. McBride,
I'm sorry.
thank you.
I'm
I was gonna
sorry.
say thank you for your arguments today, and
Okay.
I'm gonna hear a rebuttal from the amicus. Thank you
Okay,
very much.
thank you.
Thank you, Your Honors, and may it please the court. Just to start with some of the prudential concerns and why DC is the best place for the issue. First, with respect to forum nonconvenience, and whether that's appropriate or not, it was mentioned that it has, a certain number of factors.
Counsel, I hate to stop you, but could you state your name for the record, please?
Thank you, Your Honor. My name is Garfield McIntyre, Jr. It was this court, first in Lex Tex and again recently in Browder, that espoused forum nonconvenience as something that would be able to address, the concern of universities being held into DC and it becoming a national judicial forum. Secondly, with respect to, hailing universities into DC as a general matter, due process, to the Chief Justice's point, would protect those 6,000 universities if the claims did not directly arise out of or relate to contact with DC. Here, where it was the certification of the loans is legally enforceable, that contact having occurred in DC, having been done by the Department of Education, passes the minimum contacts test. And therefore, on that ground, there's no due process consideration that would prevent the university from being brought in. So any concern first has to be addressed at the outset by the university when it's determining whether to purposefully avail itself of DC programs, the actions of which can only be contemplated in DC, and the results
But
of
isn't
which.
that the essence of the government contact? The university purposefully deciding to avail itself of the programs and benefits through the Department of Education around student loans and student funding.
Well, it's certainly the first step. And of course, their reading of Lockwood suggests that it's the only one, that if it's the government, then that's it. But we think that the second step then is, once we determine that there is a contact, to look to the nature of it to determine whether or not it's commercial. Here, what the allegations boil down to relate to the provision of credit for the purchase of a for-profit service. That is commercial. And if we look at the other cases that, the Supreme Court has looked at, not necessarily making a commercial First Amendment distinction, but a case like Burger King, for example, right? A franchise agreement, a commercial contract. There, in that case, it's helpful in two respects. One is a matter of due process. The contract plus the long-term regulation that Mr. Rutzwitz was subjected to in that case was sufficient to pass due process, just as the regulation of universities would be forced to abide by from the department would also satisfy due process. And then secondly, to distinguish Morgans and Stevens, which were brought up, for example, the claims in this case don't arise out of or relate directly to the contact with the DC. In Burger King, the claims arose out of or related to the franchise agreement. So in that case, I think there's two parallels and that helps us. But I think another reason why is because additionally, the very broad position that the university presents would effectively create some sort of a conflict between Section A1 and A2, because as your honors pointed to, if contracting for services or goods would be allowable, but then any contact with the government would not be, then a contract with the government for the provision of goods and services would fall somewhere into a gray area. And that would create a conflict where one does not currently exist in DC statutory law. So I think that to avoid the creation of a statutory conflict, there has to be something that would carve out that type of interaction if it was with the government, assuming that the court found that it was, for example, protected by the First Amendment.
Where does this commercial exception come from? I know your co-counsel argued it in the amicus opening arguments. Counsel for appellees contends that there is no such commercial exception. Where is it coming from?
It comes from the early cases, Neely and Muller-Brass, and then how the court interprets them afterwards. So in Neely and Muller-Brass, Neely was effectively a journalist in DC gathering information. Muller-Brass was a wartime contractor contacting the government for information. The difference is that in those cases, when the court talked about both due process and then First Amendment, but then due process goes away, is that when we look at First Amendment contact, whether it's protected or not is very different from whether it's commercial, in the respect that even some commercial activities may be, but not these type here that are closer towards purely commercial. And that's a roundabout way of saying that there's a spectrum, Your Honor, is that on the one hand, a case like Ramamurti, which presents just the mere purchase and sale of submarines to the US Navy, is of course quintessentially commercial, and it would be hard to argue otherwise. But then strictly lobbying the government, Nartex, something similar to that, would not be. So there's really an existing body of kind of First Amendment case law that speaks to, mostly of the United States Supreme Court, that speaks to whether or not something is protected activity. Our position is that if it is protected First Amendment activity, then it would not be commercial, and of course the vice versa of that. To conclude, Your Honors, yes.
I'm sorry, so First Amendment activity cannot be commercial. There's a bright line there that you're drawing.
To be clear, Your Honor, I don't want to make that point. It's not that there's an activity that, if protected by the First Amendment, could not be in any way somewhat commercial. But I'm making a distinction between some of the purely First Amendment activity, pure lobbying, for example,
Right.
and a pure purchase and sale agreement. But even that pure purchase and sale agreement, if the university's interpretation of Lockwood is correct, is exempted. And that surely can't be the scope of the exception, which again is an exception to DC statutory law, the default provision of which is, if business is transacted, then jurisdiction does lie. The last point I would make kind of on this First Amendment gloss is just to point to the Campania case, which created the fraud exception. And I think that's relevant because even when this court created an exception to the exception, right? They're saying here's where the government contacts exception may not otherwise lie when the facts would support it. It did so on the principle that fraud isn't protected by the First Amendment. So, once we're at the second level where the court is now creating even exceptions to the government contact exception, it did so exclusively on First Amendment grounds. So before Lockwood, it was Mueller and it was Neely. Courts even referred to that later as the Mueller-Brass principle, those First Amendment concerns. Later, creating exceptions to that, it was still the First Amendment. And most recently in Browder, just 3 years ago, it was again the First Amendment, which cited Lex Tex and rose approvingly for those. The exception would overtake the rule if NYU and LYU's position is accepted here. Again, DC statutory law commands that if a party transacts any business within DC, that it is subject to personal jurisdiction. But the university's position would, if accepted, create an exception that would again swallow the rule that A2 and other of the statutory provisions would otherwise allow a party to be brought into DC for.
So so are you arguing that the government contacts exception still exists, but it's limited to the First Amendment? Or are you arguing that there really is no reason for the government contacts exception?
As of today, Your Honor, it exists and it's limited to the First Amendment. But for example, if the court wanted to visit it en banc, we think we should have a full opportunity to brief, the ongoing necessity of it in more full detail. But under current DC law, it is our position that the exception exists and is limited to First Amendment activity. And as applied to this case, the university's contacts were not First Amendment activity. They do not fall within the exception. They were commercial in nature, and therefore should subject them to specific jurisdiction in the District of Columbia.
Thank you. All right, the court would like to thank both parties for your briefs, and a particular thanks to the amicus, the University of Georgia, for your participation in the arguments here. And we'll take the matter under advisement. Thank you.
All rise.